All right, welcome to A Legal Matter if you are listening with your ear holes, and welcome to my face if you're not, or if you're using your eyeballs as well. So, this last week, it is the end of January of 2022. So, Justice Breyer is retiring from the Supreme Court, buried the lead. This is probably a harbinger of a new trend. So we'll say this much. Supreme Court appointees for the US Supreme Court have lifetime terms if they want them. If they want to stay on until they take their last breath, that is allowed by the Constitution, Article 3. But they're not required to, because that would be insane. They can retire, and many before Justice Breyer have chosen to do that. But what is different this time is that he is choosing to do so in a very strategic way, in a political way, and in a way that seems to respond to a lot of vitriol that was directed at the late Ruth Bader Ginsburg, Justice Ginsburg, for not foreseeing her own death and not foreseeing the election of Donald Trump, and failing to leave her job in time. Also not foreseeing the stonewalling from Republicans, which, you can certainly make an argument that is not crazy, that you should have foreseen the fact that Republicans were going to stonewall, because they'd done it at least once before, and they're only getting worse. But hindsight is 2020. And I don't know if I'm ready to expect all my jurists and leaders to assume the worst of all of us. I don't know. It's tricky. Suffice to say, I think a lot of that vitriol is misplaced, and we'll get to that. But be that as it may, it is there, and it certainly is something that Justice Stephen Breyer knows about. He's hip to that noise, and it seems very likely that dictated, in part at least, his decision to step down. He is in his 80s, which these days especially, it's always up there, right? But these days especially, it is uncommon for Supreme Court justices to be on that older end. We'll get to that as well. I guess there is a morbid but not incorrect expectation that those people are closer to death, so people, seeing that we now have a Democratic majority in the Senate, but a tenuous one, and a Democrat in the White House, knowing that those might swing, knowing that the balance of the court is already not leaning in a pro-civil rights, pro-human, pro-social rights, social justice, liberal issues direction. It's a conservative court right now, mostly due to legislator misconduct. But if we lost a liberal justice, and Justice Breyer was traditionally seen as a liberal, and was, as if we are aligning party delineators on stances, yeah, that's where he falls. We only have three of them. So we already, on those of us on the left of the aisle, are in a losing position as of, really, this composition came about only within recent years. It used to be probably the opposite. Certainly more will they, won't they, middle of the road type jurists, which makes more sense for the Supreme Court in any other era but the literal current one. As the branches of government go, the judicial branch, and especially the US Supreme Court, tends to be one of the more consistent, one of the more self-modulated, educated, respectful, considerate institutions. And that obviously is not due to a perfect depoliticization, even at its best, but it's, I think, a credit to the effort to keep politics out of the Supreme Court, and a mission written into the Constitution to do the same. So Again, obviously, always relative. When you get politics involved in the other branches, which have to appoint and approve, respectively, with the executive and legislative, there's going to be politics. And when you're dealing with rulings on issues that are at least inextricably linked to political issues, law and policy are like this. That's why I talk about both. So there's always going to be an undercurrent of politics. You cannot remove that. But I think for many years, or for many periods within our nation's history, the court did a relatively good job, as institutions are concerned, of being a more measured, less risky, an institution you could count on, and that did, consider human beings and also consider the import of their decisions. And part of that is because they were not beholden to an electorate. There is a real concern and pull on officials who have to consider re-election and have to consider the folks who hired them in a different way. The risk of not having that in something like the Supreme Court is you got to have a lot of integrity, and you got to be really smart and really considerate, bright, measured human beings if you are going to hold a role like that. So the selection process in and of itself, which is the inherently political part, becomes key. Because who are we picking? Why are we picking them? Why are we not picking the ones that we don't pick? Etc., etc. So that will get us into our saga. The way that I'm going to frame this, there's certainly a trackable change with the nomination by President Ronald Reagan. Reagan appointed Robert Bork to the Supreme Court in 1987. And you may have heard the name Robert Bork before. I would certainly encourage you to look him up if you're listening to this, because he looks like more fun a character than his record will suggest. You'll see, but he's a kooky looking guy. But his nomination was controversial from the beginning, and so we'll go through that. You may have heard his name used as a verb, because it is one now. It's become a word that the right likes to use as synonymous with defamation and like defiling somebody's character on the public stage and stripping them of something that they're entitled to, which, of course, even if I were on Bork's side, the fact is that any nominee to the Supreme Court is essentially interviewing for a job that will be granted or not granted to them by the Senate, pursuant to the Article 1, Section 2 advise and consent duty that the Senate has over nominees. So nobody is entitled to a spot on the Supreme Court, and this will come up again and again in this politicized era. I think most significantly with Kavanaugh, that nobody who is nominated, or otherwise, of course, but nobody is entitled to get the seat that they're nominated to. The whole point of advise and consent is that the group that is basically their potential bosses, in strictly the hiring sense, can decide that they're not fit. And they can decide that because they're too partisan, or they're too much of a loose cannon, or they're unqualified, or there are questionable things in their past. A lot of things will be ringing bells with more recent appointees who did make it through, and that proves the point that things have changed in the years since Robert Bork. So Robert Bork, why is he seen as so political, or why was he by at least the liberals and some of the conservatives in the Senate? Well, first thing is that Robert Bork was instrumental in what was called the Saturday Night Massacre in the Nixon administration, which was a piece of the Watergate scandal where Nixon's attorney general fired all these judges on a Saturday night who he knew would not agree with it, like wouldn't make decisions that were sympathetic to him and his administration, and would face cases that had to do with him. So like anybody who didn't follow Nixon's orders was fired. And anybody who could be, because there are certain that are under the executive branch, certain that aren't. Anyways, Robert Bork was instrumental in the pro-Nixon, anti-justice, in many's opinions, Saturday Night Massacre. But that obviously is a a pretty partisan use of the judiciary, if you ask me and many people. So that was his earliest significant record on the national political scene. Later, as a jurist, and I believe he was a federal judge before being nominated to the highest federal court, which is the U.S. Supreme Court, his record was very public. He was not afraid to speak his mind, and it was, well, you'll see, it certainly had a political direction to it. He was publicly against the Civil Rights Act of 1964. Don't have to say much more than that. He was anti-contraceptive rulings that the Supreme Court, prior to that point, had ruled in favor of protecting access. So there are these two cases, Eisenstadt and Griswold, that I've likely mentioned in reproductive rights settings before. And they were both decided in favor of contraceptive access, ended up paving the way for Roe v. Wade, etc. And Bork was openly, aggressively critical of those rulings. And his reasoning for that was that there is no right to privacy in the Constitution. And that's really what a lot of those cases hinge on. Not to go too far down that tangent, because you can watch and listen to some more in-depth nonsense on that I definitely have covered in the past. But the inherent right to privacy that is recognized in the Constitution and acknowledged in those holdings is what a lot of it hinges on. So there is no amendment that says there's a right to privacy, but as they put it in the Griswold case, which is one of the two contraceptive cases that Bork criticized, there are these kind of penumbras, which is shadows, umbrellas, that are created by the rights guaranteed in other amendments that definitely guarantee, under that breadth, the right to privacy, which would be a very amorphous thing to protect anyways, which explains why, they don't put the right to breathe and the right to, poop in peace in the Constitution. There's a lot of stuff that they don't expressly say, because if you list everything, this is a real Federalist, anti-Federalist dispute back in the day, but if you list everything, you're guaranteed to miss a few, and the very exclusion of them in your all-inclusive list will be proof that they're not supposed to be included, and they didn't want that. So they didn't enumerate everything, but what we do have, piecing together the other amendments, is a really, really convincing, if not dispositive, case for the protection of the right to privacy being intended within the Constitution as guaranteed to our citizens. So you have the First Amendment right to assemble and express yourself. You have the third, protection against having to quarter soldiers in your home. The fourth, against search and seizure, which is privacy of person and property. Without good cause, you can't be traipsing into somebody's bedroom or, stripping them down. These are a lot of related things to healthcare and intimate choices that you make regarding sexual activity, etc. The Fifth Amendment's right against self-incrimination. And then you have the Ninth Amendment, which is kind of this catch-all amendment, which essentially says something very similar to what I said about the enumeration, non-enumeration, why we shouldn't list everything, which is that you should not construe any of the existing amendments to deny any other rights that have not been listed. So it's this catch-all for any rights that haven't been listed, but should be protected and intuitively would be protected. So if that doesn't cover privacy, especially with the other values that are covered in the other amendments, it's got to mean nothing, because what would it cover? The Ninth Amendment would mean nothing. So that was the reasoning for the right to privacy, which is worth this little Bork-related tangent, because Robert Bork said he wasn't convinced. He said there is no right to privacy in the Constitution, and on top of that, we don't like the substantive protection for women's health, reproductive freedom for men and women, in addition to not liking the civil rights protections of the 1964 bill, etc., etc. He's an awesome guy. Not only is he super political, but he's a real douche. He also, if you're familiar with this school of thought called original intent, we'll put that in heavy, heavy quotation marks. He was its originator, which is kind of funny, right? Note the timing, that we are talking about a legal scholar, so to speak, in the mid-20th century. But suffice to say, of original intent, there is no evidence that the founders wanted their intent used as an instrument for permanent interpretation of the documents. It's quite unreliable in terms of what sources you refer to and what that would mean on technologies and realities and attitudes that are so far from colonial America. I will refer to my dear dead dad for a summary of the school of thought, which again derived with Robert Bork in the mid-20th century. Constitutional interpretation justified by certain preferences of its enactors is variously labeled original intent, original understanding, or original meaning, depending, in part, on the optimism, credulity, or political preference of the observer. It's not a reliable tool, and it really is just as political in its cherry-picking of sources, to use original intent. So now you know Robert Bork. He's nominated by Reagan to fill a vacancy on the Supreme Court in 1987, and this, at the time, was way too political. It was an unprecedented move, and it caused an uproar. He ended up losing by the largest loss margin in history, and I think that still is true. I think he lost 58 to 42, so 58 voted against him, 42 voted for. So obviously you have some people crossing over the political line there too, which is impressive. It's telling when you look at the politicization of nominees today and whether that is enough to sway folks across the aisle or cause an uproar. So even though Bork didn't make it onto the Supreme Court, and ultimately everybody, or the majority of the senators, and thus influenced by the American public, enough of them were on the same page that regardless of what party you're touting, this is too much for the Supreme Court. That, compared to how politicized current era nominees have been, and how disinclined people have been to cross against their party to vote against that piece is telling. So we didn't have a Justice Bork on the Supreme Court, which I tend to think is a good thing. But of course, the right did not go easy into that good night, and Bork's name became a rallying cry, and a synonym for defamed and fallen leaders. I don't know, but because how can you even say defamed when they literally are just citing his own writings and things that he has openly claimed as his views? It's not like he was hiding the fact that he was against the Civil Rights Act. He had written about it publicly as a legal scholar. So I'm not really sure where defamation came from in that argument, but that is what they say. Say that even though that nomination failed, it certainly acted as the first turning point, the first brick in the wall, to mix my metaphors. And it reflected, I think, very poorly on not only Bork specifically in his own views, but the bounds of the president's role in picking who should be on the court. And Reagan didn't really have the experience to know that. So didn't really know the bounds of the president's role. And boy, look at the damage that he has done, if you happen to land on the side of the aisle that I do, looking at the track record since Reagan and since Bork. So it reflected on the president as well. It certainly reflected on and had an impact going forward on the objectivity and the dignity of the court and the duty that it has to the people. Because without that, the constitutional interpretation duty that, comes from Article 3, judicial review, Marbury versus Madison, all that stuff that, we're interpreting laws in this court to see if they comply with the Constitution. Without at least an effort, a really good faith effort at apolitical, consistent interpretation, you really just have a kangaroo court that is as political as whoever is in office at the time the majority was appointed. So it reflects very poorly on the court, and that trickles down to everybody subject to the court's rulings, because then none of us trust. If you don't trust the laws, the fabric of society is at risk. Not to overplay this, but it also certainly impacted the tribalism in the Senate party line advise and consent stuff in Article 1 and how that has played out since then. So just to underscore this and compare it to pre-Bork and post-Bork current era, I think it's useful to look at votes and approval stats in really early 1900 through the 1980s. The presidents were trying to choose nominees who strove to be neutral, were open to different interpretations, were bright jurists, and were sincerely trying to do what would be respected. And this, of course, increased the clout of the court as well. But if you look at the percentages of approval, non-approval votes through the 80s, you can see such a difference in what we have now. So Justice Black, for example, was 63 to 16. That was his approval margin. Justice Stone, 71 to 6. And the reason that you get some different numbers here is because sometimes people abstain or they're not there, which is in and of itself an acknowledgement that, like, their vote isn't needed or whatever, which you never would have now. Justice Blackmun was 94 to 0. Sandra Day O'Connor was 99 to 0. And then compare that to the most recent appointee who was approved, which was Amy Coney Barrett, and she was 52 to 48. So it really did not used to be along party lines and didn't really have to be. It was, we're looking at well-qualified, truly attempting to be neutral judicial candidates before. And now, post-Bork, you don't have that anymore. And nor do the parties in the Senate play accordingly. So let's talk about since Bork from Bork to Breyer. We'll go in that range. We'll look at all the folks that you will be familiar with from the last, 20-odd, 30-odd years. If we stick to the wall brick metaphor, you get a lot of banner bricks, like, let's say those memorial ones that you can buy at the zoo so that people, know your dead person exists. You got a lot of memorial bricks in that span from 1987 to 2015-ish, in politicizing the highest court. Most of those come in the form of one, hearings, approval, disapproval, nomination hearings for appointees. You had Clarence Thomas in 1991, which was messy, messy, messy. I'm sure a lot of you know about that. It was messy really on both sides, but he was a Republican nominee by George H.W. Bush. He was credibly accused by another attorney, Anita Hill, of workplace sexual harassment verging on sexual abuse. I would say very inappropriate behavior, certainly not judicial highest court behavior. It's a story for another day, but that was certainly very partisan. But you also had Ruth Bader Ginsburg in I forget. But I think her nomination hearing is such an interesting one because it's like a snapshot of mid-shift, because on the one hand, she was approved 96 to 3. That is pre-Bork level, both sides recognize that this is a qualified person, that she is really bright, she's best of the best, she's trying her best to stay neutral and judicial all the time, which is also telling in terms of the reputation that she got later on. Because, you would think that this was a firebrand asshole with some sort of agenda, but at the time, people pretty universally recognized that she was a qualified and neutral person to hold a position. Also, the questions that they asked her were an interesting snapshot of the move towards more politicized. She was famous for paving the way for women and marginalized communities, so it was no secret in that sense, which is arguably more political, but what jurist, especially when it comes to identity issues, what jurist is not personally aligned somewhere? Who doesn't have an opinion on something that affects their literal body and ability to work? But that said, it was an open secret that she was, one of the first women in all her school classes in law school and undergrad, that she had faced barriers to practice as a woman, and thus had formed opinions as a lawyer on women's rights issues. So she was actually asked about the Roe v. Wade holding in the Senate confirmation hearings, and she answered candidly that she was pro the holding. She did talk about some differences that she had in the reasoning, which were just, she was very frank. And given that it was settled precedent, I think you'd be hard-pressed to say that that was a disqualifying sort of opinion to have, that you agree with settled precedent, but it is arguably political, and they did bring it up. Now, nominees tend to not answer because they're like, I don't know if that's going to come before the court. I do like that, I guess there's some sort of illusion of not being political. I don't like that they won't tell us. I feel like maybe people have just learned to not say stuff out loud in the way that Bork did, and then when they're asked point blank about what radical ideas they may have now, they're like, I can't answer that. You've heard a lot of that in the nominations in recent years. The other thing that creates a lot of these bricks in the wall, holdings, obviously. So many holdings, which is like rulings, the decisions that come out of the court in the post-Bork period from 1987. Obviously, a lot of them have affected a lot of social policy, public policy, all sorts of issues, but the ones that I think are really instrumental are the ones that have overturned, in which a court that is very partisan has overturned settled precedent, which you're not supposed to do. You're supposed to be bound by what previous courts did, unless, and there are like these little checkpoints that you are supposed to have to show have been met before you overturn it. So it's things like, is it unworkable? Are courts having trouble applying this standard? Have the facts changed? Has medical science or something advanced to show that this is no longer true or workable? Has society changed so much that this is no longer a good example of that one is the Brown versus Board anti-segregation decision that overturned Plessy versus Ferguson, which was a separate but equal is okay. But in that one, the societal progress was a huge factor, that norms had really changed in a way that you could even substantiate with statistics, that, this is no longer something that everybody believes. We have progressed and we've moved towards justice, and that is something that the founders encouraged, in fact. So, great. But you do have these little check marks that you have to meet before overturning something, like Roe v. Wade, for example. And there is no reason that something like that should be overturned. But in a lot of cases, with more politicized courts, these newer nominees are much more eager to just throw them out because they don't align. And I guarantee if you do see Roe and Casey overturned, they will not meet, because those standards can't be met. There is no new medical science. There's no societal shift against abortion, even though their news media might suggest it. There is no statistical difference, if anything, the opposite. So that also undermines faith in the court, right? Because if its own justices aren't even obeying their own precedent, they're just doing their own, they're just up there preaching their own thing as dicta, or, well, that's the opposite. They're dictating the law of the land without any guidance from what everybody from our founders to present has codified through decision or law. Don't even, if you're going to fuck us over, don't pretend that you're doing it in the guise of law. Just do us the favor of just saying, I want to do this because I want to do this. Anyways, so there's the overturning precedent, and then a lot of cases that I think tread on the political question doctrine, which is this standard that is applied to all courts, that they are not supposed to touch voting political issues. They're not supposed to be allowed to hear questions that are better handled elsewhere. So an example of that is, say, the Constitution assigned that type of determination elsewhere. So, this is a law that Congress should pass, and powers are delegated to them over taxing issues. So the court's not going to make that decision because it's something that the Constitution is delegated to a different branch. Or there's no manageable standard to apply. So moral issues, this is why they're always trying to find something in the Constitution, like a right to privacy or a right to free speech, to underscore it, because they can't just use politics or morals as a reason to decide something a certain way. That's not a manageable standard. So if that's what you're deciding on, theoretically, the court is not supposed to decide on these political questions. That's the political question doctrine. There are many cases in the last 20, 30 years that very compellingly would cross that line. The first clearest example I would say is Bush v. Gore, in which the court willingly decided a presidential election against the popular vote, no less. That's pretty clearly a political issue. Obviously, there was more to it than that, but still. Citizens United about campaign contributions and corporations being people, that was a very twisted way of saying the Constitution supports what we politically want to do. There was Shelby County overturning the Voting Rights Act, a couple gerrymandering cases like Whitford. But a lot of those things that impact voting, impact political issues, and impact whether the court wades into these battlefields, again, mixing my metaphors, a lot of those have come up more recently, as they inevitably will, when you put political advocates' less modulated minds on what is supposed to be a neutral judicial body that is bound by precedent.
End of part 1. Intermission.